All right. Um, well, I wanted to say hi to everybody and everyone who's watching this, whether now or down the road. I'm Ryan Garrison, Oli REI meetup group, and I'm joined today with William Shadbolt. And we are both lucky enough to be landlords in the state of Washington. And basically, William and I have been talking about this for a little while, and we've had so many changes and so many extra procedures, and just a lot of things that just doesn't make any sense at all. That have been thrown onto our plate that we have to go through and we have to abide by, and we don't even understand it. I don't understand it half the time. He's much better at it than I am in a lot of things, and I wanted to take a little time, put some information together for other landlords or people that might think they want to be new landlords in the state of Washington, and talk about how we can, things to do, things not to do, how we can actually try to do what we set out to do, which was build long-term wealth through real estate and rentals. So William, why don't you just tell everybody who you are and your credentials? And you sound you're a super smart guy, but you sound even smarter because of the accent. And I wanted to actually let you present yourself, because you'll do a better job than me.
Well, first of all, thank you very much, Ryan. I really appreciate you having me on today. As you said, we got to know each other over the last few years. My name is William Shadbolt. As you can tell by the accent, I'm not from Seattle. I'm from Vashon Island. That was a joke. So my background is I bought my first rental property in 1992 when I was at university, and I am a small housing provider here in the state of Washington. I also have a manufactured housing community in the Midwest and some self-storage. So it was kind of part of being a small landlord. When I first got involved in having rentals here in Washington State, I was like, okay, I need these forms. I need to figure out how to do screening. And actually, it was a friend of mine who said, like, you need to join this organization. It's called the Rental Housing Association of Washington. And I looked at it and I was like, this is great. I can get all my forms. I can do my screening. Cutting a long story short, got involved, got invited to join a couple of committees, then was invited to be the board. And I'm currently the past president of the board of directors, chair of its PAC, and I help run its legal defense fund. And kind of through that, I was invited to become part of the Washington Business Properties Association. I'm also president of the Partnership for Affordable Housing, and I sit on the board of Housing Connector. But, as you said, Ryan, we're small landlords, and there's been a huge amount of change in the process. And, if anybody doesn't understand it, that's okay. Because right now, most attorneys don't understand it. And when I'm not talking about like general attorneys. I'm talking about landlord attorneys that do this day in, day out.
Absolutely. I have a couple of anecdotes from that too. Like I have attorneys I've used in the past for landlord-tenant issues, and even as early as earlier in the pandemic, that were still helping, and they hadn't really adjusted their fee structure. They were still charging flat fee evictions, that kind of thing. I had two landlord-tenant attorneys specifically say, we just don't do it anymore. They keep changing stuff. They make it too difficult. They, and it drags on and it just screws over the landlords, and they got tired of it, and it's just not fun. Which I don't know if law is ever fun, but it's like extra not fun. So then two other attorneys I talked to, they doubled their cash they wanted from the landlord. And then they said, no, it's not a flat fee. That's just a retainer. And we're going to keep billing you hourly because of all the stupid continuances, all the things that they use with the free attorneys to drag it out. But maybe we should just discuss really quick. What was it like pre-pandemic? What was the process? My memory of it is I could file a 3-day pay or vacate with a non-paying tenant. And on the 4th day, I could go and file an unlawful detainer and start that process. Is that pretty accurate, or am I missing steps? It's been a while.
Yeah, that's pretty accurate. And I think it's worth going back even a further step from that of what is an eviction in Washington State. So you're going to hear use the term unlawful detainer. And in statute, that is what an eviction is. What is an eviction? Eviction is a court-ordered process to remove somebody from a property. I tell you what, it isn't an eviction is when you terminate somebody's lease. There's a lot of people, particularly on the tenant side, that say, oh, anytime a landlord stops renting, it's an eviction. No, it's not. It's a court-ordered process. So going back before the pandemic, you were absolutely right. It's a 3-day pay or vacate notice. And in fact, if you could share the screen, I'm going to kind of walk people through the timeline of what it was before. And what you've got to understand with the Unlawful Detainer Action is when the Residential Landlord-Tenant Act came into effect in 1973, it was always designed to be an expedited court process. Because think about this, a typical lawsuit, you go in, you file, you get a trial date set. It's probably going to be about 2 years in the future. And, you do discovery and you have the trial and it can go on for years. That obviously just doesn't work in a situation of a property that's being rented out and somebody's not paying, or there's a lease violation or something like that. So it's always designed to be an expedited process. And that's not what it is anymore. So what happens is, like, day one, you get the rent is due. If they don't pay, you legally can do it on day 2. Most people give the grace period. Typically it's 5 days. So the second step on this would actually be, day 6, for example. The tenant could then comply with the notice and it's done. Or if they fail to comply, you do the summons and complaint. This is basically you're serving on the tenant and filing a lawsuit to go through the unlawful detainer. The tenant then has the ability to respond to that, and then it goes into court for what's known as a show cause hearing. Now, a show cause hearing is just exactly what it sounds like. You've got to show that there's a cause of action out there. In probably now 98% of the cases pre-pandemic, the show cause hearing was the only hearing, because a lot of people just didn't bother showing up because it was open and shut. The vast majority of evictions in Washington State is over unpaid rent, and somebody's either paid it or they're not paid it. There's a small number over lease violations and a few other issues, but the vast majority is over unpaid rent. So the judge would then have the show cause hearing, issue what's known as the writ of restitution. And that is literally the piece of paper that tells the sheriff's deputies, you are lawfully allowed to go in and remove that person. So there's an opportunity to stay or suspend that writ for a period of time after it's been issued. And that gives the resident the opportunity, if there is an issue with the process or anything like that, to go to the court and say, hey, there's a mistake here. I did actually pay, but I paid on like day 8. And then there's usually a bit of a negotiation whether they want to keep the tenant in there or not. And then there's the physical eviction. So after a period of time, the sheriff's deputies will go in, and I've actually had a friend who was like, I need some people to help me move stuff out, change the locks. Are you available? I was like, hey, I've never seen one of these in live action. And the sheriff's deputies go in with guns drawn. And that was pre-pandemic. And I don't know if anybody's read the news that a couple of weeks ago, a King County sheriff's deputy was shot doing an eviction in the city of Seattle. He's still in a hospital in critical care. It was really, really sad that we've got to that point in this state. And so then there's a point where it's like the last day that you could possibly reinstate a lease. And after that, it's like the sheriffs go in, they clear anybody out of there, they stand by while you change the locks and you physically take the tenant's possessions and put them on the sidewalk. And that is how the old process worked. Now it's an incredibly different process.
Yeah, absolutely. And I'm going to pop out of this real quick. And then just for fun here. So when you do go put it, you got to go pay movers, or you have friends or whatever, and you go put the stuff on the sidewalk. I've always been kind of like curious, because I know in here we're supposed to secure the property for a certain amount of time, and so then you have to move it to the sidewalk, and then what? Do you put a tarp over it, and is that secure enough, or do you have to move it into a storage unit? And then, when that's not done, and so then you pay to move it twice, once out of the house, then you pay to move it again to the storage unit. What is your kind of take on that?
So this is a kind of an interesting area, and I do think this is something that the legislature needs to take up and deal with. So the statute says you have to put it on the sidewalk, on the edge of the property, and that's it. Now, if the tenant turns around and asks you to store it, you're required to store it. However, most of the time, the tenants are gone. They just walked away from it. And so one of the things that I've found happening throughout the state of Washington is the city comes along and says, this is a code violation.
Yep.
It's outside your property, even though it's on public property. And the landlord's like, well, hang on a second. I don't have any authority to do much with it at this point. And the city is like, I don't care. We're going to start fining you. So you end up doing what you did, which is putting it into storage. And there's obviously an expense there. So that is actually an area that I really think that ideally it would be through the legislature in Olympia clarify better what you have to do with it. But as it stands, you put it on the sidewalk. There's a right in law that if they ask you to store it, you've got to store it. But if they don't respond, what do you do with it? And you end up doing exactly what you said you do, right?
And I also want to just throw this out there now, because we didn't at the beginning. I've never been mistaken for an attorney. And so nothing I do is obviously ever legal advice. William does get mistaken for attorney often because he's very, very knowledgeable in this subject, but he also is not an attorney, and nothing he says is legal advice, and talk to a lawyer and everything else. So there we go.
And on that topic, seek professional advice for your very specific circumstances. Every single body's case is different, and if you are a landlord in the state of Washington and you haven't already got a landlord attorney, and I'm not talking about just any general attorney or even a real estate attorney, you need on call an attorney that can deal with these issues. And there is actually a very limited number of people that are very good at this, but you need to have that person available. So hopefully you never need their services, but you need to know who you're going to call if that happens.
Yeah. Okay. Well, so we've kind of gone through that process, which is pretty straightforward. It would take roughly, I would say, start to finish, maybe a month, right? After you serve the tenant, if everything went through and everything, and you'd also even at that have a judgment, right? So that would be part of the hearing, and everything's kind of wrapped up. Now collecting on it's a totally different story, but at least it would be done. You'd have a judgment. They didn't pay. They're on they went wherever they go, and it's your house again, and it's only a month. Now, usually, this is just a psychology thing. When people know they're getting kicked out of a house that they're not paying for, they don't tend to take the best care of the property. Okay. They are more inclined to be angry and punch a wall, or let their kids draw with markers, or any number of things. And I'll show you some pictures in a little bit, but at least it's only a month of that. When they know they're getting kicked out for 6 months, they have 6 months to do that to a house. And in my opinion, it's a lot worse. And so that's just another thing of this, is that time when they know they're not going to have the money, they just have more time to not take care and be the best steward of your property. But let's talk about, what does it look like? What does it look like now? So that process that was a month, that was pretty straightforward. Let's kind of walk through that. And I'm going through some of this right now, and I'll kind of chime in too, but I'm going to pop over to your screen and you can kind of walk us through it.
Sure. So this is the old process pre-pandemic. And this basically puts the previous slide in a calendar format. And as Ryan said, you're absolutely correct. It's about a month. That's the absolute minimum period of time you could do that in the state of Washington. And what's changed?
And I'm sorry, and also with that month, usually a flat fee, maybe $1,500 for an attorney fees and eviction. something in that ballpark. Does that sound about right?
Yeah,
For
the flat fees were around that for
Mhm.
most of the attorneys doing this. And as you said, the last attorney that I knew that was doing flat fees stopped doing that a few months ago for the exact reason that you said, Ryan. It's just too complex. And we'll get a little bit into why it's complex. And there's one very big reason for why things are getting stretched out excessively. So what's changed is that notice to comply period. That was changed by statute from 3 days to 14 days. That is now the longest period of time in the United States that a tenant has to pay rent. And so, one of the issues that I have with a lot of legislatures that are, their big thing is like tenants' rights or tenants' protections. We have to push this. A lot of what they push actually harms the residents because there's unintended consequences.
Absolutely.
So now what's happening is people used to have a 5-day grace period. You had a period of time. It was very informal. Now a lot of landlords are just saying, your rent's due on the 1st, it's past due on the 2nd. It takes out that grace period. So people have less period of time before they get served with a notice.
Just real quick, I thought I saw something either recently or went into effect maybe a year ago or something that now your lease is required to have a 5-day grace period. Is that am I misinformed?
You're required to have a grace period if somebody is, for example, on Social Security.
Okay.
And the reason for that is Social Security typically pays out on the 3rd. So you're required if there is a legitimate reason. So for the vast majority of people, there isn't a grace period in statute. For a very small number of people that request it, there is.
Yeah, and just do the math on it really quick. If you had a 5-day grace period to be on the 1st, but they get to the 5th, and on the 6th, now it's late. Then if you go and even if you're Johnny on the spot, which I'm not Johnny on the spot usually on my properties, and if you're Johnny on the spot, you file a 14-day pay or vacate that day. That 14 days now you're on the 20th of the month before that 14-day plus an extra day probably in there for service, right? So 21st of the month, with rent that was due on the 1st, now they're 9 days from the next month's rent. So you're almost to where they have 2 months rent right off the bat, and you were trying to be the guy right on the time to serve them right away.
Yeah, and one of the other changes in the statute as well is how you can serve. So previously there was a lot of options, and most landlords could just easily do it themselves, either by handing it over, posting it on the door, and mailing it. Now you just wouldn't do anything other than use a process server. And so that adds in a few days, because even if you send the documents to a process server one day, the earliest they're going to get to it is the next day. And usually right now, it's a longer period of time.
Can you expand on that? Because I know I'm in REI, and on their process with serving tenants and stuff, it gives you like, these are the steps you have to do and all that kind of thing. And I've done a few of these now where, I've served people. Like what is, when you say, you have to use a process server, can you kind of expand on that? Because on the REI guidelines, it doesn't have that necessarily.
Sure. So statute gives you alternatives on how to do things. Mm-hmm. And one of the issues that we're seeing a lot in the courts is that it's being challenged unless it is a process server that's doing it and has signed an affidavit. And I mean, it literally, even with photographs of it being posted to somebody's door, the tenant's still saying, well, I got home from work and somebody must have removed it. And the judge throws the case out. Uh-huh. So that's why I'm saying is like, there's certain things that the judge is not going to turn around and say, yeah, I'm going to throw this out. Serving the notice is one of the big ones that I've seen recently. There's a large uptick in the number of cases that are being thrown out because of that issue.
And I'm sure a lot of that stems from the free attorney that they get to try to challenge every possible thing. We'll get to that. Let's keep going here.
So the next thing, and I feel like I'm one of those game show hosts. It's like, now wait, or infomercial.
But wait,
there's more.
Yeah.
So during the pandemic, the federal government enacted the CARES Act. Literally in this title, it says it's a temporary act. It was very poorly drafted. It was rushed through Congress, and there is one line of that is being interpreted in probably 99% of the country as though it's expired, it's done, it has no impact. In Washington State, there are commissioners and judges that are saying that the CARES Act still applies. So what is the CARES Act? So it can only apply to covered properties. So covered properties are anybody that has a mortgage that's through Fannie Mae or Freddie Mac, anybody that has at least one resident, doesn't have to be the same resident that you're serving on, that is part of a federally subsidized program. So that could be Section 8, housing choice vouchers. It could be, if you're a large apartment, the tax credit program that the federal government has. So there's basically a large percentage of rental properties in the state of Washington that is covered by CARES Act, and you have to give a 30-day notice. So effectively, that 14-day notice, which, as I said earlier, was the longest period of time in the United States, has become a 30-day period. The next thing that it's like, oh, wait, this gets even better. There are currently litigation going through the courts because a commissioner turned around and said 2 notices served at the same time is too confusing for the tenant, and threw the entire case out. So this particular case was somebody not paying, and they hadn't paid for a period of time. It was a single family home. It was a mom and pop landlord. They just wanted the property back. So they were like, I'm selling it. I just can't deal with this anymore. So they gave notice to sale under the recently enacted Just Cause, which is an extended period from the 14 days and the 30 days from the CARES Act. And the judge turned around and said, this was just kind of like sitting, his actual language was, this was sitting in the weeds. And, you know, the thing that the discussion between landlord attorneys on this was like, these are 2 separate causes of action. There's nothing interrelated. It's like, even if the pay or vacate had been paid up front, they still had the right to terminate the lease and sell the property. And so that's going through the appellant process at the moment. But it you know, that's how ridiculous things have got, that we've gone from 3 days, you could get into court, resolve this quickly, to 14 days. Then it's 30 days. Now it's like you can't serve more than 1 notice at a time, according to that one commissioner and a couple of other commissioners. And it's just extending it on and on. The thing that really has impacted since the pandemic is what's known as the ERPP, the Eviction Resolution Pilot Program. And I think, Ryan, you've got a mediation coming up with that. So I'm going to let you tell everybody your experience.
So this exact tenant, actually, a year ago, I was going through the eviction process with an attorney, and then they even had the mediation appointment, and then they skipped the mediation appointment. And then by some act of God, they got their tax refund in time for the court. So they were able to pay the tax refund enough to satisfy the court to reenact tenancy. And so they were there, but they've been slow payers for forever. And so they'd pay rent, 5 days late, and then not include the late fee. And so then the balance, but I'm like, I'm not Johnny on the spot wanting to serve notices all the time. And I was dumb, and my lease didn't have a thing where I can add additional charges per day. And it has a pretty hefty late fee, but there's no per day. And there's also no like service charge for like when to get served. Right. And so they don't have, once it's late, they don't really have an incentive to pay today versus tomorrow. And so that was part of it. And then, so they reenacted tenancy. They've just been late, and then they'd pay like a week late. I wouldn't necessarily do anything. Okay, they have a couple $100 balance, whatever. Then the next month they pay a week late, and they still had that previous balance. Or even if they paid on time, they had that previous balance, so their rent's not current, and they'd get a late fee, and they would accumulate. So then they're $400 behind. And then that just kind of went, and I was like, whatever, they're paying enough, and I'm not going to start chasing a lawyer down and paying $3,000 or $5,000 to a victim over it. Then came like October or November, and they just stopped paying completely. And so now they've had months of, not paying. I think they paid once in all that time. And then, you know, accumulating late fees and all that kind of stuff. They also are $4,000 behind on their water bill. They haven't paid a water bill. City of Lacey still has not started to cut off water, even though they could have, I think, a year and a half ago is when they were allowed to, right? Because they know they're going to just milk the property owner eventually on it. And so that has been another thing. But, you know, again, was that something, was it directly affecting me, you know, while they're in the thing? No, not necessarily. You know, I just figured they cut it off eventually. But now we have mediation tomorrow, and I think their balance owed is over $10,000 if you add in the water, right? So what, you know, what do you do from there? And I got a little bit of a freezing. Can you still hear me?
Yep, I can still hear you.
Okay, cool. I'm frozen on my screen, so hopefully that comes back. So can you see me? Am I moving?
No, you're frozen.
Ah, son of a. Okay. Well, let's hope that comes back. But let me go here and let me pop out of that. Nope, I'm still frozen. Okay. Well, hopefully I come back. Let's. Oh, there I am. Okay, cool. Let's go to your thing. And also, by the way, annoys the heck out of me. You talk to the person at the ERPP, and they say, make sure you come to the meeting with an open mind, right? Come to the meeting with an open mind. And I think it's like, what are you looking for in the open mind? They either have the money to pay or they don't. And well, you're going to go, and I think your next slide is probably like the current like flow chart, I'm guessing.
Yeah.
Here, if you are you almost done with this one? Okay.
Yep, definitely.
Okay. So yeah. So like he was saying, we serve them with the 14-day, which that one doesn't have that on there. There we go. Yeah, almost.
Yeah, actually, I just realized this is the old version.
Yeah, that's the old one. Okay, well, I'm going to hop that out there. Maybe you can find it. But so right now, you serve them with that 14-day. You also still, from my understanding and what I've read and all this stuff, are required to offer them a repayment plan, right? And
so that requirement was initially, it was part of the governor's moratoria that is still being litigated. There was a hearing in the Ninth Circuit recently, but it got put into statute. But it actually expired 6 months after the end of the declaration of emergency for the pandemic. And so the interesting thing about that is there's still questions as to whether it's expired. Most people think that requirement to offer payment plans statewide is expired. Now, a few other cities had their own states of emergencies and their own restrictions, but statewide, that requirement for the offerment of the repayment plan, in opinion, is expired as of April 26th.
Well, and so let me share my screen with it, and I'm gonna go here, go there. All right, let me bounce over here. So in RAWA, when I go down and I go look at my tenant notice forms, and I want to go through the eviction process and that kind of thing, and I go into what I'm supposed to do with that, it still says to use it's locked. I gotta log in. Well, I'll bounce out of it for right now. But
let me tell you the reason why you should still be offering it right now is because we don't have clarity as to whether it's expired or not. There's still a question out there. So if there's any question about whether a tenant landlord has to do something, always do it, because it can't be then attacked in court.
Okay.
And so I'm happy I can offline talk to you about the conversations of like, has this actually expired or not? And most people think that has expired because by statute it was tied to the governor's declaration of emergency, which is expired.
Okay, so that's what I did in mind.
What I think would be useful, Ryan, is why don't you talk a little bit more about the ERPP and what you had to go through with them?
So yeah, and that's actually where I was going with that. So when serving the 14-day, then also at the time, and it's debatable if it was necessary, the required notice, the required repayment plan offer, right? Which can't be more than a third of more than the monthly rent and all that stuff, right? And then also this little packet of papers that says, here's the contact information for these people, and here's the contact information for these people, and the Justice Project or the Dispute Resolution Center and all this stuff, right? Because they don't think that I think just the state maybe being condescending and saying that tenants aren't smart enough to be able to Google, right? So it's like, no, we have to hold their hand, give them all these papers because they can't see it on the internet without us, right? And so now we give them all the stuff, we fill it out for them. We fill out all the stuff with all their info and all the stuff, all these extra papers. Here's all this contact info for your specific location. Then the tenant has 14 days to respond to that, 14 days to respond to the pay or vacate, 14 days to respond to the repayment plan. My tenant shows up on the 14th day, has the papers signed saying, I can't afford a repayment. And then also, yes, I want the dispute resolution center or the ERPP, those people to do mediation because they think they're going to get a lower payment with the mediation. And so that's what they did. And by the way, the paper just reeked of smoke and the thing was like, oh God, I'm sure my house smells great right now. So then you have to wait. Now that they're at 14 days, are they ready to have a mediation right then? Nope. Now you got to wait for the ERPP people. And I found this out the hard way. You also, when you post the stuff initially, you have to email them a copy of all the documents you posted. I found that out the hard way. I thought it was good enough to have the declaration of service. It wasn't. So then we go through that process and wait for them to get to me because they have a backlog of other cases, and then say, oh, okay, yeah, well, it looks like our next available is in a couple of weeks. I'll try to get a hold of the tenant and see if they're available at that time. So now you're already a month after you first posted the thing, right? You're a month there before you can do anything, and probably more. So then my experience with it was they didn't show up the first time. I think they're going to show up tomorrow because I have another one tomorrow with the same people, and we'll see how it goes. I'll try to update people.
So let me give everybody a little bit of background of what is the ERPP. So this was brought in by Senator Patty Cooder, who really dislikes landlords and will do everything in her power to make our lives more difficult. And their reasoning for this was it was based on a report that was done in the city of Seattle based on the eviction data in 2017, which actually showed there really isn't a big problem. Here's the fascinating thing that the authors of that report absolutely fail to mention. The top 5 people evicting in the city of Seattle: number 1, Seattle Housing Authority; number 2, 3, 4, and 5, all nonprofit, taxpayer subsidized entities. Literally, they could deal with a massive number of evictions just by going to Seattle Housing Authority and saying you need to have a different process on this. So that was the basis of them arguing, saying, well, we need this pilot program to try and resolve evictions because it's just not fair for tenants, which is crazy because it's like they signed a legally binding contract saying that they paid the rent on the 1st. I'm not too sure why people think that that's unfair. So it was created to use what's known as DRCs, the Dispute Resolution Centers. So the DRCs have been around for some time, and the reason for these was basically for all court cases, it was trying to have the dispute settled between the parties before a judge got involved. To try and ease the burden somewhat on the judiciary system, but partly it is actually better to mediate a settlement for a general lawsuit or a divorce or something like that. The issue with this is it's clear cut. Either they're paid or not paid in 90+% of the cases. The other issue with the ARPP is it's unconstitutional. It's a complete violation of the right to access courts. And I'm going to apologize up front. I'm going to go a little bit into history here and tell you why it's unconstitutional. And, a lot of people think, well, constitutional rights, with property, they think about takings clause or impairment of contract clause or other right to bear arms, something like that. Access to courts really isn't on people's radars. But let me tell you why it should be. It's a sign of a civilized society. It dates back to before the Magna Carta, but it's specifically mentioned in the Magna Carta as the right to basically air your grievances in front of a neutral party, a judge, and settle matters that way, without the ability for people to go and settle disputes in a civilized manner. We become savages. And that's why the right of access to courts is so important. The interesting thing, in the state of Washington, this issue has already been litigated. Several years ago, there was a change in the law on medical malpractice. And it's basically said you had to go out and get somebody do a certification to prove that you had a legitimate case before you could file in courts. And the state Supreme Court threw that out, said, you can't have a gatekeeper to going into the front doors of a courthouse. This is exactly what this is. And the Washington Business Properties Association filed a lawsuit. It was argued. Unfortunately, at the very last minute, they switched the judge from somebody who was retiring to somebody who had just been appointed by Inslee. She took over 3 months, and her entire reasoning on it was, I've read each side. I'm ruling in favor of the government. That was it. There was no discussion about the arguments we raised or anything. We appealed it to the state Supreme Court. They are taking their time to decide whether to grant it. I suspect the reason for that is they're waiting until July 1st. So by law, when it was originally enacted, we negotiated incredibly hard to get a sunset clause on this, because we didn't want it to continue without a further act. They tried the last 2 sessions, including the one that was just finished, to extend it. We managed to fight that back. So here's the good news. It officially ends on July 1. Here's the bad news. I have heard recently that there is a lot of dispute resolution centers, and you could probably guess which county I'm referring to. They just turned around and said, we're not taking any more cases. So literally between now and July 1st, you can't do anything.
The only thing you can do is try to bribe the tenant.
Has that experience? I would love to know, because I want to put that in front of the courts. So another bit of bad news is, while the ERPP program is over on July 1st, I keep track of the state's budgets. And in the House operating budget, which was, unfortunately, this part of it was what was enacted over the Senate, it increased the funding to the DRCs massively. So there was a general increase, nearly doubling the funding to the DRCs from the Senate version. There was also, and they can use that on anything, there was also $1 million specifically for landlord-tenant resolution issues in Snohomish County. So that has to be used for that. I suspect what we're going to see is basically the ERP through the back door, where you file in court, the taxpayer-funded attorney for the tenant is going to be like, this should go to mediation. And the judge just automatically sends it to mediation because it gets it off that docket. That is my biggest concern with that increase in funding, is that it's a back door. The good news about it is at least you've got in the front door of the courthouse at this point. And there's an incentive for tenants not to have that, because it's a legal record at this point. People can see that they've had a summons and complaint filed on them for not paying their rent. So it's marginally better. My concern is that it's still going to have that issue that you mentioned, Ryan. And, at the start of this, the DRCs were basically like, we're not equipped to do this. We don't know how to do this. And they just delayed massively. I actually know one person, it was 6 months before the DRC. I've known multiple other cases where attorneys wrote to the DRC threatening to sue the DRC for not issuing the certificate. And then there's other attorneys that basically wrote to the DRC saying, we've complied with every part of the law. You're refusing to issue the certificate. If you don't issue the certificate at this point, this is going to be Exhibit A when we go to court to show that we've complied with it. And so that's the issue. And it kind of goes back to what right at the beginning of this, Ryan, the unlawful detainer process was supposed to be an expedited process. It isn't anymore. It's like, I do actually believe mediation has a potential role. However, it should be overseen by a commissioner or a judge. And it has to be when the parties are both willing to negotiate. And what we've seen is that tenants just don't bother showing up. And the DRCs are like, well, we'll contact them again. We've got to give them the opportunity. We've got to contact them again. That's and it just... This is your example. Exactly.
So I couldn't get the certificate then. I'm like, well, I showed up. They didn't show up. Can I have my certificate? And, I want my participation trophy for like showing up. and they're like, well, we're going to try to get a hold of them again and all this stuff. And then finally, like 3 days, 3 days later, they actually gave it to me, which is better than your situation they're talking about. But I have to go through all of that just to get a piece of paper that says I can file a legal action like you're talking about. And I agree with you completely about making it so we're not savages. I mean, I know you saw the landlord in Seattle that they pulled the tenants out of the sound.
Yeah.
I mean, so, and now we'll just say that's wrong. Don't do that. But I can see where he's coming from. So the thing is you take away someone's worked their entire life. To get some property to maybe make a few $100s a month in cash flow. Okay. Between the spread and maintenance and the spread of their debt and that kind of thing. And then now you have the government comes in and says, well, you know what? I'm not going to say it this way, but what we really are saying is we want to force you to provide free housing to people that don't really deserve it or shouldn't get it. Or we're not going to pay for the free housing. We want you to pay for it as a landlord and private property owner, and not give you any way to enforce any type of law to get them out and control who has access to your property.
Yeah, you're exactly hit the nail on the head. And here's the thing: there is a reason why we have what's called the takings clause to stop government from doing this. In fact, I do kind of remember from my history classes that there had to be a little bit of a dust up between England and some colonialists over the right for the British to force soldiers into the homes of people in the United States. And so, that's kind of the issue on this, is that there's politicians that are out there that literally on the record said that landlords shouldn't make a profit. Housing is a human right. Well, okay, if it's a human right, why isn't it in the Constitution or an amendment to the Constitution? And so that's kind of this issue that we have. We were the only state in the union that had a moratorium during the pandemic that not only did you tenant not have to self-certify, they just didn't have to self-certify. It included billionaires. If your billionaire was renting a property, they could stop paying rent. And that's one of our big arguments in litigation that's continuing on this, is that the US Supreme Court ruled that self-certifying was unconstitutional. So Inslee giving a blanket authority for anybody to use it without having to even self-certify, in my opinion, is one step worse than that. And that's
go ahead. I'm sorry.
No, go ahead, Ryan.
Well, I was just going to say that I'm okay. I'm not okay, but I could accept and tolerate. I think that's a good word, tolerate. A government in an emergency situation requiring private property owners to provide housing, not free housing, but provide housing, right? If the government says, you know what, we're going to, offset, we're going to compensate the landlords, the property owners, and do that. And then what did we do here in this country, in this state, is we gave all sorts of stimulus to these residents directly, cut off the balls of the landlord of taking away any ability they had to enforce tenants paying and tenancy of the property. And so now the tenant has all this money. I mean, I know people, we all have stories, but I know specifically, those brand new Lincoln Navigators that are about $100,000. I have a friend in Spokane who had a tenant that beginning of the pandemic, just like, nope, not paying. And brand new $100,000 Lincoln Navigator in their driveway, 6 months later, right? And they're just paying that instead of paying the rent, right?
Here's the interesting fact: the government required no other industry other than landlords to provide a service or a product without the possibility of getting paid. They didn't require supermarkets to provide free food. That's a bigger necessity for human existence than a roof over somebody's head. But now that you've mentioned your friend in Spokane, I feel as though I've got to talk about a couple of people I've spoken to. One landlord out in Yakima, she was renting somebody who was a nurse, clearly employed. The nurse turned around and said, "The governor told me that I don't have to pay rent." They listed the landlord as a reference on a new car loan for a Cadillac SUV. The bank called her up for a reference, and she was basically like, I don't want to even talk about this. Landlord down in Lakewood, small apartment building, I think it was like 8 units, had one tenant. Not only was he not paying, he was going to the other tenant saying, you shouldn't pay You don't have to. There's no legal requirement. And the other tenants were all paying. And in fact, they were then contacting the landlord saying, hey, we just don't think this is fair. The guy shows up with a Maserati sports car. Landlord up in Snohomish County, tenant doesn't pay for ages. And then the landlord is a single family home, turns around and says, I'm selling it. And the tenant at that point owed about $30,000. And the tenant turned around and said, we'd like to buy the house. And I was like, well, hang on a second. If you can afford a down payment, that's the $30,000 that you haven't paid in rent.
At least they had it.
That guy is kind of a little bit of an idiot because you just go and get a judgment and it would attach the property. But that's the issue on this. And I just wanted to be really clear. I had no issue whatsoever with people that were actually impacted by the pandemic. In fact, I got somebody who's a full-time tattoo artist as one of my residents. He contacted me and said, listen, William, my business is just closed down. I'm not going to have any money until some assistance comes. Can I work with you? And I was like, absolutely. In fact, I referred him to an assistance program that paid his rent for a couple of months. That, no issue at all. What we have an issue with, and what we're talking about, is elective non-payers, people that have the ability to pay but chose not to. And that's the issue that Washington State has. We're the only state that encouraged that by having no requirement to be impacted by the pandemic. And that's why there's still litigation going on those moratoria.
Now, you touched on something with your assistance. Now, let me give you something. Part of this was the same exact tenant I'm dealing with a year later, right? So it was last year, was it at the end of April, that there was a landlord assistance fund or organization, something.
There's actually multiple ones.
And I think it was going away at the end of March or April, something like that. And so I got in, I had two properties past due on the rent. One of them was this one. And I submitted all the stuff I could for it. Now, one of them, the tenant did not reply to the repayment plan, right? Okay. Well, here's all my stuff. Here's the thing. Here's the ledger. Here's everything I can give you. The other one, they did reply to it. They replied late, so 14 days. They replied like 17. They also whited out on the date of it and said, we messed up on the date. Here's this thing, whatever. I'm like, okay, fine. We'll do the repayment plan, but hopefully I can get this covered with the state. I'll get some money back, and then we'll get things rolling. Well, after waiting for all this stuff and waiting for a response, both of those claims were denied. And, to me, it was probably $12,000, right? And the reason was, well, one, they signed the thing late and they used whiteout on the form, so we can't approve this claim. I'm like, what does that have to do with whether or not they're getting evicted from a house or what they owe? And the other one, well, they didn't accept their payment plan, so we can only help them if they default on their payment plan. They defaulted on the rent payment plan, right? Like, what? Yeah. How does this work? What kind of world is this?
So when the feds threw money at the states to use for this, the state actually had a lot of flexibility on how to use the money. Most of the money actually went out to individual counties to hand out. Some counties were great. They got it out the door pretty quickly. King County, they waited several months and then sent out a questionnaire to landlords saying, how can we do this on an equitable and inclusive basis? We want your feedback. And I was just like, get the program up and running and send it out. Why the person that ran that program, did a terrible job, is still employed by King County, I don't know. But one of the programs of what you're referring to is run through the Department of Commerce. And it was basically if a tenant accepted a repayment plan and defaulted, you could then go and get the money. And so for the tenant that didn't accept it, clearly they're not eligible. The one that did, the whole whiteout, that is just, they were looking for reasons to turn it down. I don't believe, and without seeing the correspondence, that that's a legitimate reason to turn it down, because that money was designed for exactly this purpose. Somebody's accepted a repayment plan. And so there was a big push. It was like, great, you get a signature on a repayment plan, they default, you can go get this money. That program is finished, by the way, for everybody's listening.
Is there are there still any assistance programs that are working? Because on RAWA, I saw one on there. It's like, oh, well, your tenant, or maybe it was on actually the correspondence with the ERPP. Like, here's our example mediation thing. And then there's a thing in the bottom, landlord can apply for assistance. And I'm like, is there even any out there?
All the main ones have expired. So the money that went out to the counties, that's all expired. There are other rental assistance programs out there. that are much smaller and less funded. And here's one point that I really want to make. The amount of money that the state of Washington has spent on the ERPP and the DRC is phenomenal. I have a report that was made to the legislature. They could have spent that money on rental assistance and people would have been better off.
You could have got everybody paid up.
Yeah, that was kind of one of the interesting things that in the report that was done on the eviction data in 2017, 76.6% of all evictions in the city of Seattle in that year could have been paid off with less than $1 million. And I was like, well, hang on a second. The city of Seattle has a housing levy that includes money that goes to eviction prevention, just eviction prevention. The same period of time, they spent $2.6 million on eviction prevention programs. I don't know about you, but $760,000 is a hell of a lot less than a couple of $1 million. And the problem is that they deliberately wait until literally the very last moment. The sheriff's about to serve and execute on the writ before they'll come in with that money. And what there should be is a shift. It should be means tested so people can't play the system, but it should be earlier in the process because it saves us time and effort. It saves the tenant from going through this process and it'd be much better. However, there is a lot of people that don't want it to be a quick one. And that's where, you know, the one other big thing that happened in the state of Washington is tenants get taxpayer subsidized attorneys. So I'm going to give you a little bit of background on that. The law was written by a guy called Edmund Witter, and he runs the Housing Justice Project that is now funded by that. Bit of a conflict of interest there. You write a law, you get it enacted that's basically going to pay for you. There's other issues that I have with that. So they have an incentive to waste as much time as possible and extend court process cases out as long as possible because they get paid more. You know, so again, another conflict of interest. I have heard, but I'd like to get a verification on this, is that they won against the landlord and they asked the judge for attorney's fees, even though they had already got money from the state of Washington, which I think is absolutely
oh my God. And the landlord's
wrong.
paying, I mean, they're paying their taxes, right? So
Yep.
I was just going to say, we need to get to, because we were spending all that time on the ERPP, we didn't even get to the attorney part after you actually get the certificate and you can file your unlawful detainer.
Yep.
Right. And so now let's talk about this. So we're so gracious here that we provide a absolutely free attorney. So for anyone that's getting evicted, and now this tenant has someone in their corner to be their advocate and help them. Well, all I've seen them do is advocate for more continuances and delays to actually make the process take longer, give the tenant more time to feel like they own the home, like that guy that, you know, shot a cop in King County and damage the home. Like, I don't see where it's actually like helping anybody, but we give them a free attorney and they have no incentive at all to wrap things up quickly. So my theory with it is, even instead of a free attorney, even if the tenant paid $25 an hour to their attorney, because I don't get a free attorney and I have to pay $350 or, you know, plus or minus depending on which county or where you're at an hour. If the tenant had some skin in the game, just like Section 8, and Section 8, they still have to pay something towards the house, right? So I don't see how we can continue to just give free continuances.
So I just want to clarify something on this. Is the statute requires them to be low income, but the definition of low income is incredibly high. The reason for that is our state constitution, you can't use public funds other than, literally it says poor as one of the exceptions to that. I know multiple cases, people that are employed with six-figure incomes that are getting the free attorneys, that the landlord attorney complained and the judge just was like, nah, he needs to be represented, might as well use this attorney. And so we've gone to this ridiculous situation, and they are appealing things that are just unbelievable. Because, hey, why not? I'm playing with the house money.
I can extend free rent. I can extend half of anything. And that's what I'm saying. Even
free attorneys pushed the application of the CARES Act for 30 days. It was clear that that was only a federal law that was temporary for the pandemic. The pandemic's over. There is actually a bill in DC, which is one line that just basically goes, by the way, this has completely repealed and doesn't apply anywhere. So, that's the issue that we're seeing with these free attorneys or taxpayer subsidized attorneys for tenants, is they are just pushing it. So one of the bills that we managed to defeat in the legislature would have actually created a pilot program for a housing court. So the only other place that I know that has a significant size that has this is New York City. And you look at the problems in New York City on how to get rental properties, because people just don't want to rent there because of issues like the housing court. And so, we managed to kill that in the legislature. So, let's look at, what is the unintended impacts of all of this? Small landlords are just selling. The one place we know, because of the rental registration inspection ordinance data, is the city of Seattle. I have rentals in the city of Seattle. As they're becoming vacant, I'm selling them.
Yeah, I'm selling mine.
It's just not worth it. Milton Friedman, decades and decades ago, in fact, Nobel laureate for economics, looked at the connection between regulation and the reduction in the supply of rental properties. And yet there are people in the city council in the city of Seattle that think they are better than a Nobel laureate economist on that relationship there. And they're like, well, they may just not be registering. It's like, no, they're selling. We can look at the data of rental properties and think about it logically. You have a property in the city of Seattle, an average house is close to $1 million. If you've owned that for more than a few years, you've got a reasonable amount of equity. And I always say, it's like, when you're looking at an investment opportunity, what else can you do with your money? What else can you do with your time? And so people are saying that, and like, well, I can continue being a landlord in the city of Seattle. My profit margin is getting less and less because I'm getting restricted more and more. They just enacted maximum $10 late fee. And it's not $10 a day, it's $10 total late fee. And so people are just like, well, I might as well sell it and take the money and invest elsewhere. And there's a lot of people looking at investing outside the state of Washington if they want to stay landlords. Or, you can literally put money in a CD right now and make more money. And so what happens to that single family rental property? It becomes owner occupied, because the next person, even if there is a landlord that's interested in buying it, when you have a property that's $800 to $1 million, you can't make it work. The numbers just don't work, particularly with mortgage rates being higher. And so what you're seeing is, and a lot of people think that, rentals, it's just this homogenous group of properties. It's not. There's a very different sectors in the residential rental market. If you want a studio unit in South Lake Union and a big high-rise new apartment, there's loads of them, because that's what's been built in the last 10 years. There's more rental apartments being built in the last 10 years in the city of Seattle than the 100 years combined before it. So if you want that sort of thing, there is availability. Now, if you're a family, a couple of kids, you want to be in a good school district, good luck in finding a single family home. There's very few of them available. And what is available, the rents have gone up, because that's one of the very few ways that you can mitigate the risk. And rental criteria has gone through the roof. I know for a fact, First in Time, literally when they came in and said, you have to take the first person that meets your rental criteria, I went from half a page of rental criteria to 8 pages long.
Absolutely.
And here's the sad thing about it. Again, unintended consequence. I'm probably a little bit more liberal than your average landlord and willing to take a risk on somebody. I'm more likely to take somebody with a housing choice voucher. That's just kind of how I am. Now with First in Time, I have no discretion. I've had people saying, it's like, I've got this voucher, I've got this. Or even if they don't, they come around and said, I had this issue, I had to declare bankruptcy 8 years ago. I turned my life around. Like, nope, can't take you. City of Seattle says I cannot take you.
So
I would meet my criteria.
So my background previous to going full-time real estate was I ran sales teams that specialized in bad credit auto loans, right? Bankruptcies, repos, and I would get into people's credit and their lives and their history and everything, and that was part of it, was finding the people that just they're great folks, but something bad happened, and being able to tell that story to the lender and get them a better loan, right? And I I would always, with my tenants, I would find people, I would try to find people that, like, you know what, maybe they're only a 600 credit score right now, but they have good income, and they offered to pay a little more a month. They offered to pay a double deposit to offset the risk. So now, just like in a car loan, if someone's risky, the bank can say, you know what, we want to see 40% down payment, right? So we want 40% down, and we're going to charge them a higher interest rate, higher payment. So now with the rental, you say, you know what, this person, I'm a little bit more risky. I understand. I'm willing to pay a little bit more a month. I have good income. I can support it. I have more money initially to put down to get into it with extra deposit, maybe first and last month's rent, that kind of thing. And you know what, if they had a good story and I like the people and I can work with them, I'm compatible with them personality wise, then I could put them in there. They want to take that out of there, because you're in a relationship with someone for a year, 2 years when they're your tenant. But now, just because of this paper, I have to accept you.
Like, yeah. And you kind of hit the nail on the head. That you used to have the flexibility to have other ways to protect your asset, because let's face it, there's two things that you get when you're a landlord. The rent is one, and it's really important that we get paid, but the actual underlying asset and taking care of it is much more valuable than the rent that you're going to collect. And so that was one of the reasons for the purpose of having a security deposit. The city of Seattle has restricted that. You can't do more than a month's rent. You've got to offer a repayment plan. So there's no flexibility there. So you deny those marginal people. Now, if you were a large apartment complex, this was never an issue, because they always had very high standards. And it was like you passed or failed. There was just no discretion whatsoever. The mom and pop landlord is more willing to take a risk on somebody like that. And the city of Seattle, everything that they've enacted has made it worse. So there was 5 major changes from 1973 to 2016 in residential landlord-tenant that affected Seattle property owners. That was based on the Residential Landlord-Tenant Act, which is statewide, and other issues that were specific to Seattle. There's now over 20 since 2016 that's been enacted. So you look at this and you think, well, am I likely to be, do I want to be in an industry that is just so regulated that it's impossible to make a reasonable return? Or am I going to invest my capital elsewhere? I mean, we've spent most of this conversation talking about the eviction process. So let's talk about additional restrictions in the city of Seattle above everything we talked about, of the CARES Act, 30-day notice, the dispute resolution centers, the free landlords, everything else. In the city of Seattle, you cannot evict during the winter eviction ban, because we have such harsh winters in the city of Seattle. So you've got a period of time you can't do that.
Can you start the process? Can you start the process in the winter knowing it's not? Oh my God! I'm not going to evict you till it's nice out.
Yeah, you cannot file.
Oh my God!
You have the school year ban. So if you have kids in school or a teacher, even if you're a janitor, there's basically any connection to a school, you cannot evict during the school year. So let's think about that situation. Add the winter eviction ban and the school year ban. There's literally only a very narrow window.
And it takes longer than that window to do it.
Exactly. Exactly. So one of the bits of litigation that I'm interested in, we've been talking with the Rental Housing Association, some of our friends at Pacific Legal Foundation, is we've challenged a huge amount of these laws in the courts. Unfortunately, a lot of them get upheld. We've had some good wins. We went against the city of Burien trying to make fixed-term leases illegal. I personally sued the city of Seattle on its rental inspection. I had to force them to roll back into the most recent amendment. So we've had some wins, but they're very limited. One of the things that I would love to put in front of the courts is the pancaking effect. If you take all of these changes in laws, does that become a taking? Because at some point it has to. And their argument, the way that they get around this, which is very frustrating, is that they turn around and say, these are all defenses to eviction. We're not saying you can't evict somebody. We're just giving you an additional defense. And so state law requires a city to comply with state statute. They can't do something that's directly, but that's the little loophole that they use to get around. And when you actually look at the case that came from, which was the Kennedy case, it's actually a very narrow ruling and it shouldn't apply. But they basically turn around and say, oh, it's defense to eviction.
My thing with the landlord-tenant law is now it doesn't make any sense unless you have like an on-staff attorney, and in like the big corporations can be landlords and they can handle it because they can process everything quickly, but at least on their end, and it's more affordably on a per eviction basis. But I'm right now, I had a property, I had some equity in, like you're talking about in Seattle, but my cash flow, my gross cash flow was only like $600 or $700 a month. And the person didn't pay. You have legal fees, and there's probably $30,000 in damage on the property. How many years does it take to recoup that at $600 a month? Right? I don't get a stay on my taxes. I don't get a stay on my mortgage payment. I don't get a stay on my insurance. Right? But this one bad person, I'm going to show you this. Let me just pop over here to this really quick for fun. But I'm going to share a screen and give you kind of an example. Okay, so here, go here, show on stream. There we go. So this is kind of fun. So it's like I think they had pets and they just pretty much ate. I don't want to edit the album. I want to display a picture. Come on, get out of here. All right. So the tenant the dog just ate the seal around the door, right? Like, oh, I'm gonna go ahead and do that. And this is when I went to serve them. Actually, this is the front door. This is the service. There's no handle on the door. Where did the handle go? I don't even understand. Like, where did it go? And the door just like pushed open, and I'm like, holy cow. So that was when I decided I'm not going to work with these people anymore. I'm actually going to evict them and get them out. And the smell of it. This house was my second house with my wife that we owned. And it was a nice enough house at the time. Whoops, there's all that, right? Nice big house, 2,700 square foot, right? Go into that. And then let's just go in here real quick. Scroll. They put in like these raised bed things that had all this gravel and rock and stuff over the yard. And so they ended up moving the beds when they left, but then there's all this rock and stuff just all over the yard. How do you have rock and everything? They didn't take, they had this was the cover for the crawl space. They had done something and stepped on it and broke it. Inside the place, they've got dog smell, carpet everywhere is trashed. The kids were allowed to run around the house with marker and just draw wherever, right? Like do whatever they want. Wait, there's more. Where'd it go? You can see. It was nice of them. They left like piles of garbage because they didn't want to pay for garbage service anymore, right?
At least they put them in trash bags.
Yeah, at least they did that in this one, that part of it, not all of it. Then, you go into some of these rooms and you see holes in the carpet where they let their dogs do whatever, and then the dog just dug up a hole, right? And I don't know why all the screens and all the windows, they let the dog just like tear holes in them so you can see them from the outside of the house. You go in and...
So let me ask you this question, Ryan. When you did the move out checklist, how much was all the cost of all the damage on this property in total?
So that's kind of an estimate because this is still ongoing. I don't have my bills for some of the work, right? This is still ongoing. And then the place is completely uninhabitable. So now theoretically, if I actually could collect on it, and if it takes you 4 months to actually get all the work done on a place and get things done, is that something you can add to your judgment as all the lost rent when they were still supposed to be in there renting that whole time?
Good question. So you could make a claim on it. Whether a judge will uphold that or not, I think it really comes down to the judge. So one thing that you probably may not be aware of is the one residential landlord-tenant bill that was enacted this year in the state legislature was on security damage deposits, and we managed to negotiate moving it from 21 days to 30 days to get your statement back, and that comes into effect later this year. And so that gives you a little bit more time, and it's good for landlords in some ways because it gives a much clearer what documentation you have to provide. Wow, that handle's broken.
Tell me you don't watch your kids. Tell me you don't watch your kids without telling me you don't watch your kids.
Yes.
Right.
We could do an entire podcast just showing each other the videos. I had or I still have a duplex in Seattle, small 2-bedroom place, 680 square feet, cost $2,300 for the trash removal when they moved.
Listen to this. Listen to this. If you can hear the audio. I'm going to see this. It doesn't quite do it justice. So the tenant, I'm like, it's really cold in here. Like the windows are foggy and everything. So I go turn the furnace on, and the furnace is like. Now this technically was in a lease option, and some of these things were their responsibility. But this is a 1-inch filter with a lot of dust and webs, and been there forever, and was super dirty. And one of those like 4-inch thick filters.
It looks like it should be for a 4-inch filter.
It is. It is supposed to be for a 4-inch. You're right. And like this is some of the, yeah. So this is just the sort of stuff. And
here's a top tip for you. I did this with some residents of mine. Is that they were terrible at doing replacing the air filters. Mm-hmm. So I found there's several websites that will sell online filters, and I required in the next lease renewal that they sign up for a service that automatically debits their credit card and sends them furnace filters every so often. So they just literally show up on the tenant's doorstep, and they have to take it out of a packet and replace it.
And this is a me thing, and I know I fail at this in particular. I am bad about going and doing like quarterly walkthroughs on the properties and that kind of thing, right? Usually if the rent's coming in, everything's good. Like usually I'm like, all right, cool. And I've been bit by that. That's a mistake on my end, and I know that. But here's my workaround, and here's what I think I would like to get, or have someone to hire someone, is what if you pay someone to go and put in your filter for you on a quarterly basis or every 4 months or that kind of thing. And while they're there, they happen to also be like, oh, this is how many people are living here. This is obvious damage. Oh, there's pets. This is pets that we see, obvious smell misuse, that kind of thing. And they just boop, 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 when they do the filter, and then they give that back to the landlord. I feel like there's a need for that for landlords that like, I want, I'm getting this done as part of your lease. I'm going to go ahead and take care of that filter and get it done for you. And then that's our walkthrough too.
So the interesting thing about that, Ryan, is a lot of property management companies will do that. I know somebody who owned one of the larger ones, and their policy was they did a drive-by inspection once a month, take photographs, send them to the owner of the property, and then every quarter did an internal inspection. And it's an interesting idea. The question that I have is, your average small housing provider, how much would they be willing to pay for that service? And I'd like to say that most small landlords are frugal, but the relative is we're cheap. And so, I think there's an opportunity there, and you should be inspecting regularly. Absolute minimum, you should do an internal inspection once a year prior to you deciding to renew their lease at all. But in reality, you should be going in there once a quarter. That's not unreasonable. You can give notice. If they refuse entrance, there's penalties for doing so. But you've got to look after your asset. It's really important for you to get out there and put eyes on it. Being a housing provider in the state of Washington is not the hands-off passive investment that a lot of people put it out to be. You've got to actively look after your investment and be a good housing provider by saying that. It's a lot easier. I remember the Rental Housing Association has monthly meetings that are usually held at a restaurant. You pay for your own meal, you have a discussion, it's kind of great. And there was somebody there that was like just railing because their tenant had moved out and they'd done all this damage. And I was like, oh, how long had you been there? 21 years. When did he last do an inspection? They hadn't been inside the property for 21 years. I was like, that's on you, because it's easier at the start of that relationship to say, oh, by the way, part of your lease is this. Classic example, I had one tenant, I did the lease renewal, and she wrote back this scathing letter saying, we have weeds out here, we have this, we have that. And I literally took a lease and copied and pasted all the sections. And everything she mentioned was her responsibility to do.
Mm-hmm.
Never heard about that again. And it's like that's the thing. You've got to have a really great comprehensive lease. If you're not getting it from RHA or one of the other big associations, I'll guarantee you that don't comply with all state law. And you take the individual sections and you train your resident. The resident's either going to train you or you're going to train the resident. Mm-hmm. And, you have that ability to say, and I always do it kind of a nice, friendly letter to start with of, hey, just a reminder. And then if it doesn't get done, I'll follow up and say, I'm giving you until such and such a date to do it before I'll take any other option. Mm-hmm. So it's important to get in there and look at it. So I have to tell you two stories about tenants moving out. One was the bomb squad. Had to have the bomb squad come along because they turned around and said, "Can I have fireworks?" I was like, "No, you're inside the city limits of Seattle. Fireworks are banned." And they're like, "No, we were just talking about those little like champagne party popper things." Like, well, they're not fireworks. You can have those. They're not fireworks legally. So they had apparently they'd gone up to the Indian reservation, which it's unlawful to let those fireworks, a lot of those fireworks off anywhere other than the reservation and certain federal lands, which there aren't any that fall under the category in the state of Washington. And they had altered them. They'd like tried to tie them together by putting poles and fuse together. And we just take one look at this and we're like, we don't want to touch these things. And I could call up a friend who's a landlord attorney, and he was like, hang up and call SPD and have the bomb squad come out. And they were cool. They literally went in there, the whole full body thing, put them in a bomb-proof box, took them out. And then different tenant went there, and there was a grenade. Fortunately, the gunpowder and the actual priming part of it had been removed, but it was an actual grenade. Mm-hmm. And I remember I grabbed it because I thought it was kind of cool, and I was using a friend's car at the time, so I just threw it on the passenger seat, completely forgot about it until my friend picked the car up and was like, "Why is there a grenade in my car?"
Yeah. Oh, man. Well, and so I guess, William, what you had some other stuff there. Why don't you tell us maybe what is some stuff coming down the pipeline? What are you seeing that could be good for landlords? What do you see that's going to be bad for landlords that's coming up that we can kind of stay on top of? Because it is very fluid.
Sure. So I got one last thing on evictions to mention. Okay. One of the issues that we are having, and it seems to be getting a little bit better, except for King County, is there's an extended period of time before the writs are executed. So when you finally have that writ of restitution that gives the legal authority for the sheriff to come in, you obviously have to give it to the sheriff's office. And at one point, King County Sheriff's was basically like, we just don't have the staff to do this. The reality of it is they had staff, they just decided not to allocate resources to it. Mm-hmm. And so there's this extended period where you could do the writ, and typically it was a week later you had it executed and the tenant moved out. Now, that period of time is like 40 plus days on average when it's good. In certain jurisdictions, a lot of the smaller counties around the state, they're much quicker at doing it. But this is an interesting one because they've actually changed in King County from an elected sheriff to an appointed one. But a lot of sheriffs around the state are elected, and it's like they answer to you. Write to the sheriffs if there's a period of time saying, why are you not allocating resources to do this? This is important. We've had it, it's delayed enough. Can you please put those resources in? So that's kind of like just one last issue that has been a significant change in the unlawful detainer process.
And a part of that, I will say too, all these things like were by and large for tenants, right? And there were protections for foreclosures and homeowners and that kind of thing, but not quite to the same level, it seemed, right? So what I had an attorney tell me was it takes basically the same amount of time now to foreclose as it does to evict. And my instinct is the process is a little bit more straightforward. And so now I've done this with some of my properties where I'm actually selling them on a wraparound note. So I'm still able to get some cash flow, get a little bit of a chunk down, because it's more of a negotiation of the down payment and what they have up front, instead of I'm required to accept this because of this. Right. And so that is something I've started doing, is I'm trying to like distance myself, but now they own the home. So I don't have really the same rights to go walk the property. And I was bad at that anyway. But now they're the one getting the bill from the HOA. They're the one getting the property tax bill, that kind of thing. And so far so good with those. They know they own the property, and I'm getting cash flow out of it. So that's one shift I've made. But I definitely am getting ready to start 1031ing out of properties, because I just do not want to be a landlord here anymore.
Yeah, and the numbers just don't add up. So one little bit of good news is, in fact, I think it was actually the very first bill that the legislature passed. It went through both the House and the Senate unanimously, was to deal with an issue that, this sounds crazy, but quite often when people will sell houses, they'll do a lease back. So this is a case of like, you got a house, and I'll give you an example. Kids are still in school until June or whatever it is, and they put it on the market. The person wants to buy it. They're willing to let the current owner stay there until the end of the school year. They do a simple 1 month, 2 month lease. Well, because of all these rights, they were classed as though they were just a regular tenant, and there was a couple of cases where they're like, "Yeah, I'm refusing to move."
Well, in Seattle, I just made $1 million. I got $1 million in my bank account.
Exactly.
And
I'm going to go ahead and $1 million. By the way,
I like my waterfront house. I like my nice house on whatever, Lake Washington, whatever. Right? And I'm just going to milk this for a couple of years, see where it goes.
Yep. So the governor signed that bill, and so that exempts those leaseback situations from the Residential Landlord-Tenant Act. It needed to be changed, so it's good. So what can the individual landlord do at this point? Well, I think there's really two things. One, make sure that you're a good landlord. Do those inspections. Educate yourself on these changes. One of the best ways to educate yourself is become a member of one of the associations. Rental Housing Association of Washington is great. It has a whole bunch of on-demand classes. You can take them anytime. You can take them in the middle of the night. Then there's like 168 of them. I'll guarantee you, if you have a question about rentals, somebody else has had the same question. And if there's enough people that have had the same question, there's a class to educate yourself on that. And then the other thing on that, it kind of ties in with associations, is get involved with one of them. It's like, it costs usually, I mean, I used to say between $200,000 and $250,000 to take a case to the state Supreme Court. It's actually quite a bit more than that now. I see the bills regularly. And so for an individual landlord, the only people that ever do that are the very large owners. So how does a mom and pop landlord protect their rights? You donate to the Legal Defense Fund at RHA. It's better to hang together than hang separately. So, help fund that litigation. And we've had some major victories over the years. The reason why you do not pay tax on rents is because the Rental Housing Association. It's a Schumacher case. The state brought in a tax on rents in 1959. RHA challenged that in the courts, and it was ruled unconstitutional. The other associations this year, they were going to increase the real estate excise tax. We already have the highest excise tax in this country, and they're going to raise the top level again. Over the next 3 budget cycles, that was a $2.16 billion increase in taxes on real estate. We managed to get the original capital gains tax bill had real estate included in it. We managed to negotiate that out. That was a massive win. You think about it, every time you sell a property, you'd have to pay an additional 7% on the profit to the state of Washington. And I've got to tell you, the state Supreme Court, the decision in that was horrible. It is one of the worst pieces of legal reasoning I've ever seen. It was an opinion piece more than legal reasoning. The only part of that was reasonable was the 2 dissenting justices that got it right. It is not an excise tax, it's an income tax. Everybody else in the country calls it an income tax. Everybody else on the planet calls capital gains an income tax. It doesn't act like an excise tax. It is an income tax. And yet because, equity and diversity demanded, and,
Oh my God.
we need this money for this stuff. 7 of the 9 justices said it was an excise tax. There is a potential to challenge it 2 ways. One, appeal it on a federal claim on there, because it actually breaks the federal constitution by taxing people outside the state of Washington. And there's also the possibility of doing what's known as an as-applied challenge, which is somebody who's actually had to pay it sues, as opposed to what this was, which was a facial challenge saying it's unconstitutional in any circumstance.
Mm-hmm.
So those are really my 2 big thoughts. Be a great landlord, educate yourself, get involved in one of the trade associations, whether it be WBPA, RHA, the Washington Multifamily Housing Association. We all work together to try and protect the property rights, both in the legislature and through the courts.
Oh, that's good advice. I definitely, I first signed up for RAWA because I just wanted to get a copy of some of the COVID forms, because the COVID stuff, everything happening, I don't know what forms I need. I can't just do the normal stuff. And I don't know. I'm of the opinion that you should be able to evict. It should not require like a degree to be able to evict somebody. It should not require a law license to be able to evict somebody. And that technically doesn't, but it almost does, right? Like even on the RAWA guidelines at this point, contact attorney, right? Why do we have to be in such a complicated place? It's not a complicated concept. Someone is not paying as agreed. They cannot stay there, right? And so now in the spirit of inclusivity and equitability and all that stuff, like it's not fair to expect people to have consequences for not paying for housing. And so I'm trying to wrap my head around, but why can't it be as simple as a small claims court that says, here's your lease. Okay, do you sign this lease? Okay, here's your payments. Do you dispute the payments and the timing and what you owe? No. Like that's really how simple it can be, and is a lot closer to that in other places.
Yeah, it is. And so I guess, you're raising a point here that there's a political aspect to this.
Oh, 100%.
One other bit of advice I'm going to give everybody that's listening to this is you've got to get engaged. You have to contact your lawmakers. If you don't know who your 2 state House reps are and your state senator, there's a simple website. You type in your address, it tells you. You need to be, every time you have an issue like the ones we've talked about that are making it harder and harder to be a housing provider in the state of Washington, you need to email your state representatives and state senators. If you're in a city with a whole bunch of protections, so we're talking about the city of Seattle, Olympia, Spokane, Bellingham, you need to be writing to your city council members, explaining your side. Because the other side screams and shouts, but we have logic and reason on our side, and you need to communicate to your lawmakers. And if you don't vote, you need to vote. That's just if you have the right to vote and you don't vote, just don't get any sympathy from people ending up with the political situation that we have right now. Fortunately, right now, the Democrats control all 3 branches of government, because the governor appoints judges. All the House, the Senate, and the governor are obviously all Democrats. We've got the longest running stretch of having a Democrat governor of any state in the union. However, there are moderates on both sides of the aisle, and it really is those moderate Democrats working with moderates in the Republican Party that have helped prevent some of the worst things that have been proposed. We had 5 rent control bills, 5 of them proposed this year. All of them died.
That's good.
And that was a big fight. It was a huge fight. I thought one of them was going to get through.
I wouldn't even care. Like, honestly, it's so ridiculous that like that's how far I've fallen. Is I'm like, I wouldn't even care if rent control passed if I could just get rid of people sooner and control who's in my house. Like, just let me do that, right? Yeah.
And here's the thing, right? There's another part of it, like control who's in your house. the right to exclude is a fundamental right. And what do I mean by fundamental right? So there's certain rights you have by statute, there's certain rights that you have through the Constitution. And then fundamental rights are actually more powerful than that. The US Supreme Court has ruled the right to exclude is a fundamental right. It did so very clearly in a case called Cedar Point recently. And that was a takings case. There are courts that basically said because they ruled that it was a fundamental right for takings, but not for regulations, then it's clearly not a fundamental right for regulations. Well, hang on a second. It's either a fundamental right or it's not a fundamental right. You can't have a fundamental right for one part of the Constitution and not for another part of it. And so, that's what a couple of the different cases that we have proceeding at the moment. We're waiting for the opinion to come down in the Ninth Circuit in a case called El Papel, Jevons, and then Gonzalez in the state court system. And, we're prepared to take those to the US Supreme Court. I think we actually have a pretty good chance, particularly the El Papel case. And the reason that I think we've got a better than usual chance is out in the Eighth Circuit, they ruled that the governor's moratorium there was unconstitutional. And so you've got one part of the country controlled by the Eighth Circuit that has a ruling one way. So worst case scenario, and we tend to believe that the Ninth Circuit usually is going to rule against us just because of in the Ninth Circuit, which basically covers the West Coast, that if they rule against us, we can go to the US Supreme Court and say, listen, there's a difference in law here. You need to step in and settle this. And they're much more likely to grant a petition in that case. One of the things we haven't mentioned that was really great news that came out of the Ninth Circuit is that they ruled that the city of Seattle's ban on looking at criminal records was unconstitutional.
Jesus.
Huge win. That's a case. I was involved in that from 2017. It feels like it was 1917. It's been going on that long.
You're older than me, but I don't know.
Yeah, when Seattle proposed that, originally they proposed it. It was a lot more reasonable that you could look at records, but you had to say why you were turning somebody down. But if you acted on those, and during the process, they're like, nope, you should just ban looking at records. And I was there for the hearing in the federal courthouse, and one of the justices turned around to the attorney for the city, and it was like, so I just want to be really clear. If a landlord's talking to a prospective tenant and says, what criminal records do you have? That's banned. And the city of Seattle is like, yes. It's like, and you could just see on the expression of the justice, it was like, why are we even having this discussion at this point? You're impeding free speech. Now, there was one aspect of it that they did rule in favor of the city of Seattle, which basically was the adverse action part, which is a little bit nonsensical that you can look at the criminal records, but you can't take adverse action on it. And so there's motions to on that in the Ninth Circuit. We expect the city of Seattle will appeal and ask for what's known as an en banc review, which is in most circuits is like then all the judges. The Ninth Circuit is so huge; it's actually a subset of all the judges. I think it's 11 judges when it's an en banc ruling as opposed to the usual 3. And then potentially if the city loses there, they may appeal it to the US Supreme Court. They may just turn around and say, yeah, we lost this battle. They could come in and enact something that's more stringent than what we have right now, but less than the complete blanket ban that they did enact. And the interesting. So
I was going to say, are they trying to do the same thing with like credit score, credit rating, or something like that as well?
Yes. So the latest thing on Swan from Councilmember Swan is banning the use of credit records, which is just crazy. It's like, okay, let me get this right. You're trying to make the argument that the history of somebody paying their bills isn't going to be a good indication of whether they can pay their bill, their rent, going in the future. It's nonsensical. It really is. Well, the good news is we're really just trying to wind the clock down right now with the city of Seattle. We're 26th of April today when we're recording this. Elections for 7 of the 9 seats later this year. the majority of people that are on the city council aren't running for re-election. If you are living in the city of Seattle right now, you should be very interested in those 7 elections later this year, because that will change
the whole state, really, because so much comes from Seattle when it comes to these sort of policies. It's like the seed is planted there, or the virus, I guess, the agent 1 is agent 0 is there. It always seems like, and that's where, that's super important for everybody, what happens there.
Yeah, RHA's always had this kind of moat idea of like, let's just try and keep all the bad ideas enclosed in the city of Seattle. And unfortunately, they've and some other allies have been effective in going to some of the smaller cities in Kane County and getting this. So we've seen some terrible things happen in the city council in Burien. I mean, they had a city council meeting a few months ago where the city attorney said, we lost this lawsuit that RHA brought. We can't enforce this part of the city code, so we should amend it. And you had city council members literally turning around and saying, well, that was just one lawsuit. We don't have to abide by it. I was like, literally the Court of Appeals has turned around and said, you can't enforce this. And you're trying to turn around and saying, we should just ignore them. And it was literally one council member majority to get rid of that section of the code. That's how crazy, slightly less than half the city council is in Burien. That I actually nearly wrote to the city attorney. I was like, can you give a remedial class in constitutional law, because they swore an oath to uphold the Constitution and they just ignored it at that point. City of Kenmore enacted a 180-day rent increase notice, a whole bunch of other things, which was bad. We've had some successes in a few cities on the east side, but you're right. These bad ideas spread from the city of Seattle. And it goes to, and it's not just King County. City of Bellingham looks like there's going to be another initiative on the ballot to bring in these tenant protection ordinances. I think there's a potential of something down in Olympia. We managed to negotiate incredibly hard with the city of Spokane. One of the proposals was just ridiculous. It was a ban on the use of criminal records, and we were like, you should probably wait until this lawsuit's finished. So I took that off the table.
The other part of it, two parts. One is that they're looking at it through a utopian lens, that everyone who is in a house is a good person who's going to take care of a house, who wants to pay rent on time, and isn't going to break any laws or have any sort of problems, right? And that's how they picture everybody when they try to make these sort of things. Well, these are all really good people that want to take care of the place. They want to pay the rent. They want to, and we have to make sure that all these really good people that are going to take care of the property and pay their rent on time can get in there right away. And just, there's not a realistic human approach to it. It's this utopian, communist, socialist, however you want to look at it, view that you want to make everybody have that same thing, and not everyone's the same. And then you're in that relationship, personality wise, you can have conflict with, just because of different people, right? I'm going to get along way better with this other person than person B, and I don't have that choice. So everything about it's messed up, and that's why I wanted to get with you on this and chat with you about it further. Did you have any other points you wanted to make, William, on here? We're about,
not really, but I just kind of summarize. The system takes a lot longer. There's very specific issues and reasons for that. You definitely should, if you don't already have one, make sure you find an attorney that practices this area of law, so you know who you're going to contact if you have an issue. And I'd say get involved in an association, get educated, and get engaged with the political process. That's really important.
You do a really good job of that. And, you're always the guy on social who's very specific and accurate with your responses to questions that people might have. And that's why I thought you were an attorney, like right off the bat. You just kind of had that attorney look about you. And I find out otherwise. But
if it's any consolation, other attorneys think I'm an attorney. I've actually been in court where the judge basically was like counsel, and then you could see the judge was like, "Oh, sorry, hang on a second, you're not an attorney."
play one on TV. Well, awesome, man. Well, thank you so much for getting on here and doing this. And I think we're going to need to do it again. And
I think we
you know,
should.
as
I
things
really
change.
enjoyed it, Ryan. Thank you for having
Yeah.
me here. I do appreciate the opportunity to chat with you.
And that's awesome. And yeah, and I think the name that ChatGPT helped me come up with this was ridiculous REI. I think, you know, or ridiculous rentals. I think that's definitely a good way of describing how our state is run right now when it comes to this particular subject. So thank you, and we'll do it again soon.
Take care.
All right, buddy.